Hey guys, this is Ben from Level Cut Law. Today we are going to talk about testamentary trusts. What are testamentary trusts? Testamentary trusts are trusts that are contained in a will. What is a trust? It's a legal mechanism in a will which empowers a person called the trustee to hold property or assets on behalf of the beneficiary. It gives the testator, the person making the will, control over how and when the assets are distributed. Why? Why do people create testamentary trusts? Very simple. They don't want, when they die, they don't want the beneficiaries to inherit everything in one lump sum. Let me give you an example. If you allow children to inherit hundreds of thousands of dollars, even millions of dollars at the age of 18, 21, 25, I can guarantee you they are going to buy Mercedes, Maseratis, they will go to Prada, Gucci, and they will squander all the money away. So the testamentary trust, is created so that the executor or trustee under the will, essentially the same person, usually a much older person, will hold the assets on behalf of the children until they reach a more mature age. For example, 25, 30, 35. I've even come across people who set the limit at 40. So a typical testamentary trust would direct the trustee to hold the assets, and hold the assets until the beneficiary reaches a certain age. During the period of time before the beneficiary reaches a certain age, for example, 30 years old, the trust money can only be used for living expenses, educational expenses, medical expenses, but other than this, the beneficiary is not allowed to demand or ask for any other things. A testamentary trust can also be structured such that the money is disbursed in tranches, in batches. For example, the person making the will can state that when he dies, he wants 10% to go to the son when he reaches 18, 20% when he reaches 25, 25% when the son reaches the age of 30, and the balance when the son attains the age of 40. One important consideration when you decide the age of the beneficiary that the money should be disbursed is to consider the age of the trustee. For example, if the executor and trustee is already 40 or 50 years old, and you have a young son, and you want him to get the money when he's 40 years old, so that is about 35 years old. You've got to factor in whether the trustee will still be alive. The chances whether the trustee will be alive when the beneficiary, the son, is 40, whether he'll be alive to give the money. Well, there's also this thing that if the executor dies, his executor will be the executor, but that's a totally separate video. Now, from time to time, I get clients coming to me doing a will. They say they want to create a trust for their children, grandchildren, great-grandchildren, for their education, all that, blah, 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 blah. The short answer is, such trusts are called private company trust. You actually need to create a company, and you have to get a corporate trustee, which charges quite high, like 3 to 5% per annum for, and then you got to get lawyers and all that. So unless you've got $20 million, don't even think of creating such private trusts. Most trusts, most testamentary trusts that are created by law firms are simple trusts whereby the trustee holds on behalf of a beneficiary. If you want to create complex trusts for future generations or for charitable trusts, Most banks will do it for you for free. Why? Because they earn money from the investments. That's why they'll provide you free lawyers, free trustee, free everything. So that's all for today, folks. Thanks for watching this video. Don't forget to click like and subscribe.